Hi, everyone. Thank you for joining today's webinar presentation, Patent Drafting, a Year in Review and a Look Ahead. I am Gail Martin, Associate Marketing Manager at ReadTech, and I want to cover a couple of things before we get started. Please feel free to submit questions during the conference by using the chat or Q&A feature. We will be sending you a copy of the slides and a link to the recording from today's presentation. Now I'd like to introduce today's presenters. Brian Alias. Brian is one of a handful of directors responsible for intellectual property product management at ReadTech. He has worked in the online information industry for over 27 years and held various intellectual property-related positions, including Director, IT Strategy and Development for Matthew Bender, LexisNexis IP Online Content Product Manager, and IP Product Analyst. Brian is a registered U.S. patent attorney with a Juris Doctor degree from Pepperdine University and a bachelor's degree in chemistry from Miami University of Ohio. He is a member of the Colorado and Pennsylvania bars. Joining him is Dave Stitzel. Dave joined LexisNexis in 2005 as a corporate legal client manager and transitioned to LexisNexis IP Solutions as a consultant in 2017. Prior to joining LexisNexis, Dave obtained extensive experience drafting and prosecuting patent applications as a patent attorney. He has also had 2 years' experience as a patent examiner with the U.S. Patent and Trademark Office. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Brian.
Thanks, Gail. Good afternoon and welcome, everybody. I'm Brian Alias, and with me again is Dave Stitzel. We're excited to have you joining us today. Today we're going to cover a variety of things specifically related to patent drafting, where we are today, what's transpired in the last year or so, and where we think we're heading. We're going to provide you with a bit of a statistical backdrop, things that are happening with applications as within the office, as within PTAB, and the bar in general. Some of the new challenges that are facing patent attorneys, the heightened importance of quality work product and patent quality, measuring success in the related analytics, and substantive developments in the law that are impacting prosecution. Dave's going to go into some detail with some cases in that space that I think you'll find quite interesting. And we'll also take a look at where we believe we're heading, the wider adoption of efficiency tools and analytics, predictive analytics and filing, and then AI-driven drafting of applications and responses. So we're going to cover a lot of territory today. I think you're going to find it very interesting what we go into. And without further ado, I'm just going to go and continue now into the substantive items. First is patent applications. It's interesting to see what activity has taken place specifically to patent applications. If we look at the numbers, China has really begun to emerge as a significant player in the space. Well over 1 million applications were filed in China in 2016. If we look at some of the other offices, the EPO, JPO, US, and Korea, they seem to be relatively stable with not big jumps or leaps over the last year or so. If we look at actual numbers, China now is up to 1.33 million patent applications filed back in 2016. If you notice, back in 2011, that's where they began to edge out the U.S. in terms of total number of filings. So a staggering number of applications being filed in China. What's interesting, however, is if you look at the breakout as between foreign and domestic, most of the filings in China are domestic. In fact, if you compare foreign filings as against the U.S., in the U.S. now, more than half of our filings are foreign, but a far greater number than what we see in China, over 300,000 as compared to the 133,000 in China. So interesting stats regarding applications and activity specific to those. If we look at the types of entities that are filing, as you might expect, large entities are filing the lion's share of applications as within the U.S. In the office itself, statistics related to cities in the office, there were roughly 319,000 grants last year. First office action pendency is close to 16 months. Total pendency, 24.2 months. I don't believe that includes RCEs. They have an unexamined backlog now in the office of 546,286 applications. That has been, it's been around 500,000, 600,000 in the last couple of years. The RC backlog is around 28,000, 29,000. The total number of patent examiners has really fluctuated in the last couple of years, oscillating between roughly 7,800 to 8,200. So we're a little bit down on the counts in terms of total number of examiners at the moment. One interesting thing that we have happening this year, and I think it's kind of exciting, is we're going to attain patent number 10 million, probably sometime this summer. So within our industry, we have our own little Y2K event coming up. So we've been prepared for this change, and it's hard to believe now we're going to break that 10 million threshold. I've been in this business now for quite some time, and it's something that we never thought would happen, but here we are. Okay. An interesting aside is if you look at the patent bar exam results and you think about the number of examiners we have today, the number of people practicing patent law, it's always a curious thing to see what's happening as within the patent bar and what new entrants do we have who is aspiring to practice patent law. And if you look at the number of exams for the last few years, there's some interesting takeaways. One of the things that you'll notice is that starting right around 2013, the number of those applicants sitting for patent bar exam has decreased somewhat steadily. We're almost off by 1,000 when we look back on 2012, so it's a significant decrease. Coupled with that, fewer people are passing as well. So you have a decreasing number of people taking the exam and a decreasing number of people passing the exam. So I thought that was a bit interesting. I don't know if it's a big prognostication as to what lies ahead, but an interesting data point nevertheless. Going to PTAB now, there's been a lot of activity in PTAB, well over 7,900 petitions, big emphasis in inter partes review, not surprisingly. If you look at the breakdown by the field of technology, the lion's share has been electrical computer, almost 60%, maybe not surprising as well. But if you look at the stats in relation to those petitions, it's pretty telling, I think. And it's no big secret that PTAB is quite the challenge now for practitioners. If you look at the number of claims that were found to be unpatentable, either all or some, that's right around the 81%. So only 19% of those claims addressed actually survive. So PTAB has been pretty hard on patent owners. Okay, so those are some stats that are hopefully interesting. Maybe some of them you were familiar with, some of them not. Nevertheless, I'm going to go ahead and move on now and talk about our environment and some of the challenges that lie ahead for patent attorneys. One of the things that we see happening are significant changes in the law, the introduction of the AIA, moving from moving over to first to file has been a significant event for us. Harmonizing our laws with those of the broader international community has really changed how we think about filing procedures and getting things into the office. There have been significant changes in technology, basically big data coupled with machine learning. Deep learning AI is creating a whole new way of looking at information, and particularly when you're dealing with aggregate information and how you use aggregate information to essentially better understand the behavioral characteristics of the different players that you're working with, the different entities, and performing predictive analytics to understand what might happen in the future. You have changes in perception. At one time, a lot of analytic solutions were considered out there and weren't widely adopted. I think we're seeing far broader acceptance now of analytic solutions. And changes in the economy. It's hard to argue that the economy isn't doing well. Certainly we've come a long way since 2008, 2009, very low unemployment rate right now. The market has been advancing in an amazing way. in the last year or so. So big changes, some of them very favorable changes. Okay, so one of the things that patent attorneys are facing at the moment is an increased need for speed. There are a lot of pressures to move quickly, to move with efficiency. Probably the first is the AIA first to file. Moving from a first to event to a first to file was a really big deal, because now if you're second to the office, that can be extremely problematic. You can't swear behind dates, so that's changing a lot of what we see. Alternative fee arrangements and what you might even call the commoditization of prosecution calls for greater efficiency, right? If your fees are fixed, you want to move things through as quickly as possible. And then some of the technologies of today are just faster paced technologies. Things are moving very quickly, and that'll probably continue so as we introduce AI. The firepower that we bring to finding creative solutions for big problems will be fairly significant. So technologies are moving at a very rapid pace, which means that our innovations are more perishable. They have a shelf life, and that shelf life could be somewhat limited. So if you don't get a patent within a reasonable period of time, you may not have a reasonable period of enforcement. The emergence of file history analytics, this is something that is becoming more widely adopted. Essentially, you can create what you might call report cards now for patent examiners, but also for those engaged in filing activity as well, including attorneys, see just how efficient they are in their dealings with the office. How do they compare as against benchmarks of their peers? So that's growing as well. Coupled with that, you see a renewed emphasis on patent quality, because you need to get to the office quickly, because there are a lot of new ways to check quality. Attorneys need to be more careful. So you have to be faster than you ever were before, and you have to produce better work product than you ever did. At the USPTO, not surprisingly, every time they come out with a strategic plan, their 5-year plans, they talk about quality. That's always one of the fundamental pillars. Not long ago, they had the Enhanced Patent Quality Initiative that resulted in 12 new programs. If you go to the USPTO.gov site, you can read about those programs. On their desktop, they also have some capabilities as well to better judge quality. We'll talk about that in just a little bit. Pre-issued submissions for those who don't do preliminary searches of the prior art or who don't canvass the prior art. They may be surprised by third-party submissions that affect almost knockouts of some of their applications. Post-grant review and inter-parties review are certainly helping to drive quality as well. And another thing, too, that you see is crowdsource prior art searching. This is where you have large aggregations of experts who actually can be called upon to research specific issues as related to given niches of the prior art. As I mentioned earlier, we see an emergence of file history analytics. We think that those are going to be purposed in a variety of ways. They are predictive. Also, they help you to make workflow-based decisions where you want to move with a particular filing, how you can be most effective, how you can optimize your outcome once you're in the office. And then coupled with that, we see new patent quality analytics algorithms. A variety of vendors offer a way to assess patent quality, and there are a variety of dimensions that they look at. I'm actually going to talk about some of those in a bit, but it's interesting to know what those dimensions are, because ultimately the results of your efforts will be gauged somewhat by these algorithms, and it's useful to know the types of things that they're looking for so you can get a sense of what might actually happen with one of your filings in the future once you go to grant and in the years after that. Okay, so quality has always mattered. An investment in an application can be substantial. As we know, it's $10,000 to $20,000 per application. If you add additional authorities, that adds up. And then maintaining your grants can be very expensive. In the U.S., that's right around $13,000. I think if we were to do the actual math, it ends up being right around $12,600. But it's quite a bit, and that's for large entities, less for smaller entities. But if you're going international, maintenance can be very expensive. It can be over $100,000. So the point here is that the investment up front can be very expensive. Poor quality can result in a failure to achieve grants. So certainly, if you don't have a quality application, it may be that you don't get the grant that you're pursuing. So all that money invested in pursuing the patent becomes economic waste. Poor quality can result in claims that are insufficient. So if you're looking to cover a specific product with a particular patent and the patent is defective or problematic, you may find there's tremendous opportunity costs in not getting that right. Where you thought you had a competitive advantage, points of differentiation is within the market, you may discover that you don't have that at all. There's tremendous opportunity costs. The other thing, too, is patents provide notice, applications publish. Poor quality can result in the notice of your invention with a failure to secure rights. So if you file an application, you're providing notice to the public once that publishes, and if you fail to secure the rights, your competitors now know what direction you're heading in, and your competitive blockade, right, doesn't exist if you don't receive the patent. So that obviously can be problematic as well. So if we think of patent quality, obviously at the bottom of the screen, you see that meeting the legal requirements of patentability, probably the key thing that we care about and what is being dealt with on a daily basis, right, in prosecution with the office. But there are a lot of other things that you need to think about. How significant is this technological advancement? What's the shelf life of that advancement? Is this something that I can guard as a trade secret? Am I better off doing that? We know once it goes into the public that we may be more compromised into the future. Are we capturing the broadest scope of the protectable invention? So if we fall short in our claims, we may have a disappointed client or a disappointed company in that what they thought they had covered, they didn't. And it's not unusual where you see narrower claims or maybe there was a broader scope available. Are you adequately protecting the actual innovation associated with the product that you're looking to protect, right? Do the claims in the product actually have some logical nexus or don't they? And does the innovation have a perspective or established market value? If the patent were to issue, would it provide some form of value? And I think value probably usually falls into three categories. One, does it provide an opportunity for some form of monetization? Two, does it generate some form of competitive advantage? Or three, does it help you avoid certain types of cost or problems? Sometimes they're useful as bargaining chips. So it's a variety of things. And then lastly, I'm going to mention, is the application technically well written and easy to understand? And I know sometimes people will actually argue that. We know, for example, that our patent thesaurus is sometimes used to find those more obscure and unusual terms to describe things. But the danger you get into is if you go to translate and your application sometimes is a little inconsistent or perhaps somewhat vague, those translations, what turn to be small things and relatively de minimis and non-problematic in the U.S. can become far bigger issues when you translate, because subtle distinctions in our language can be much larger distinctions in other languages. So do be careful about that when you draft. There are broader benefits of patent quality. I'm going to try to appeal to your altruistic nature now. One of them is the enhanced certainty regarding the scope and validity of granted patents. So people know what you've claimed as your turf, what they should avoid. There's enhanced certainty regarding the likelihood of assertion. When you're clear and your turf is understood, people know where they can venture and where they should not venture. This would result in decreased litigation. As I mentioned earlier, the avoidance of economic waste is important. Litigation is expensive. Settling out and licensing are expensive. The cost of acquiring a worthless asset is a cost you don't want to bear if you're pursuing a patent that ultimately you end up abandoning, or you narrow down the claims so much so that it covers practically nothing in the marketplace. You spend a lot of money on acquiring something that has zero value. And then there's the cost of maintaining those assets as well, which can even be adding injury to insult. Also, too, from the broader perspective, again, appealing to the altruistic nature of all of us, there's a cost society incurs via market avoidance. If you have a patent out there and it has no value, perhaps it's unenforceable. Market entrants who might have provided and helped build out a particular category of technology may not. They may not enter the space at all, particularly when these patents are owned by fairly aggressive entities. And then lastly, there's a lesson pool of investment. And this really, I think, falls down into individual companies and the decisions that they make as to what they want to patent or not patent. Anything that you pursue will bite into some budget and creating problems possibly with opportunity costs. Lastly, there are a lot of new ways to gauge and test patent quality. And we'll talk about just a few of those. The first being, within the USPTO itself, they are improving the methods in which they examine patent applications. Additionally, too, there are fee-setting authorities so they can encourage or discourage the types of behaviors they want to see. If they increase the cost of number of independent claims or number of total claims and add to the fees, it has a bit of a chilling effect for doing some of the things that the office would hope that you would avoid. But also, too, their desktop tools, EDAN has some capabilities now wherein they can check some of the dependency errors, look for lack of support in the disclosure, inspect the claim hierarchy, and look for common errors in the claim. So they're beginning to automate some of their processes. They started that several years ago, and it wouldn't surprise me if with time we don't see more activity there. It's exciting to see that because we know in the commercial sector for some time now there have been some very useful tools that allow you to essentially error check and identify anomalies as within your applications. The other thing you're seeing are the emergence of file history analytics. And file history analytics enable a lot of interesting things. One, it allows you to predict some of the outcomes of an application once it enters into the office and an art unit and examiner are assigned. You can better prognosticate as to where you're likely to go within the office. If you're dealing with an examiner who has a very low likelihood of allowance, you may find that you're going to encounter issues within the office versus someone who has a much higher likelihood of allowance as well. We see crowdsource prior art searching emerging in the last several years, both in the commercial space and also for free. Article 1 Partners has now over 40,000 participating researchers. They've awarded over $8 million to date as across their researchers for identifying prior to relevance to specific cases. Another site, AskPatents.com, is a free offering. Haven't looked at that in a while, but we know it's out there, and users of it are able to essentially pose questions to the crowd to see if they can maybe help them identify prior art or actually ask other questions in relation to patent practice. Okay. I mentioned before the emergence of patent quality algorithms and rankings, and there are a variety of vendors now who look specifically at patent quality and try to help you gauge the quality, both so you can see where there are licensing opportunities, opportunities for monetization, and also ways in which you might be able to control costs and maybe prune out your patent portfolio. And I'm just going to talk about some of those dimensions. The first dimension being forward citations. Forward citations are sites that point back to any given patent. So who is citing back to this patent? And you look at different things. You look at the number of citations that cite back to the patent, but you also look to the character of those citations as well, and the character of the classes that they fall in. Are they growing and expanding? Are they shrinking? Where are the different citations coming from? Which countries are they coming from? Which markets do they represent? So it isn't just a simple count, but it's very useful to understand from the technology perspective what value might this patent have in the marketplace. Another thing is family size. A larger family size suggests that the patent has value over a significant number of markets, and those markets can tell you where there's potential, where there's dollar potential, but also, two, it suggests to you the relative level of investment and the belief that the owner of the patent has in their technology and where they want to be able to protect that technology. Backward citations are useful in that they suggest the level of scrutiny that the innovation was given and how carefully it was considered, and it suggests, too, how well-tailored maybe the specification and claims were factoring in the prior art, so they can be useful as well. Whether or not maintenance fee payments have been made are an indication. Interestingly enough, in the U.S., once you get to the third tier, roughly 50 to 60% of patents abandoned, which is a pretty huge number. And that can be for a variety of reasons. The technology may have gone stale, or it may be discovered that the product they wanted to back didn't show market promise, or they've moved on to a new technology. But maintenance fee payments can be indicative as well. There are other metrics that are sometimes used, number of claims, elements, and words. Can be interesting. I don't think it's as helpful. Number of classifications suggests the breadth that the innovation might have. If you see a great number of classifications, particularly if they're disparate classifications, that suggests that this technology or this innovation has value across a variety of sectors. The age and remaining life, if it's a patent that's a little late to the game, it may not have as value as one of the earlier patents. If its remaining life is really short, it doesn't have a lot of value, only in that if it's set to expire in 6 months, there's not a lot of opportunity really to leverage that patent. The elapsed time from application to grant can be helpful. Typically, if it sits in the office, if it's too short, that can be problematic because you probably didn't claim all that you could have. If it's too long, it's likely your claims are going to have been narrowed. If you've been through a whole series of iterations with the office, it's likely you've had to narrow down the claim substantially from where you want it to be. Other things that are looked at are the experience of the inventor. Is this an inventor who has several patents out there already? Is this a new examiner or a seasoned examiner? What's a relative level of the practitioner? Where you see an inventor who has, sometimes dozens of patents out there from a large entity, a seasoned examiner dealing with a seasoned practitioner, it's fairly likely that the level of quality for that patent is going to be higher. Lastly, and perhaps in some ways the most significant, are litigation outcomes, post-grant wins, and licensing, where you have actual evidence of the value of the patent, where a patent has been successfully asserted and damages are covered. That shows value if it survives re-examination or scrutiny within PTAB. That has value if there's licensing data. Sometimes you see that, for example, in SEC reports, where you see actual licenses having been taken out that have dollar values associated with them. That has value as well. Okay, so we're going to switch gears now, and earlier I introduced Dave Sitzel. Dave's going to join us now and talk about some of the substantive changes that have occurred within drafting, those items particular to the practice, talk about a few cases that I think you'll find to be of interest.
Thanks, Brian. So with respect to patent subject matter eligibility and 101, there's actually a two-part analysis for determining whether or not there's subject matter eligibility within a claimed invention. The first part of the test is you must determine whether or not the claimed invention is directed to one of the 4 statutory categories set forth in 101. So you're looking at whether or not there's a process, a machine, an article of manufacture, or a composition of matter. And the second part of the test is to determine whether or not the claimed invention is wholly directed to subject matter encompassing a judicial exception. If it is, then you actually turn to, next slide, a 2-step Alias framework for the judicial exception. So under the first step, one must determine whether the claim is directed to a judicial exception. And examples of a judicial exception include an abstract idea, a law of nature, natural phenomena, and a product of nature. If the claim is in fact directed to a judicial exception under the first step of the test, then you must then determine whether the claim contains an element or an ordered combination of elements that constitutes an inventive concept sufficient to transform the nature of the claim into patent-eligible subject matter. So what does that mean from a practical standpoint? Let's turn to a handful of cases exemplifying the two-step framework. So the first case, two-way media versus Comcast, the claims were directed to methods of sending and monitoring receipt of audio-visual information. The court held that that was an abstract idea. Two-way actually argued that the claims were directed to a scalable computer network architecture that solved various technological problems, which led to an improvement in the functioning of the system. The court, however, held that the claims did not recite a saving inventive concept under Alice Step 2 because the claims only require conventional computer components operating according to their ordinary functions. Moreover, the court noted that the claims themselves did not recite or refer to a scalable computer network architecture as argued by two-way, and thus the claims as a whole do not amount to significantly more than the judicial exception of an abstract idea itself. So a key takeaway from this particular case is that an inventive concept cannot be described merely in the specification alone. The inventive concept must, of course, be found in the claims themselves in order to transform the nature of the claim into patent-eligible subject matter. Next slide, please. So in the next case, Cleveland Clinic Foundation versus True Health Diagnostics, the claims were directed to methods of detecting elevated myeloperoxidase or MPO levels in a bodily sample of a test subject relative to MPO levels in bodily samples of healthy control group subjects, and then making a correlation of those results to an increased risk of cardiovascular disease. The court held that these claims were directed to methods of observing the law of nature that MPO correlates to cardiovascular disease. And they also said that there is no saving inventive concept because the method claims were essentially directed to observing this naturally occurring phenomena. And then also the MPO levels were just measured using known techniques, routine steps, commercially available detection kits, and conventional statistical methods for making those correlations. So a key takeaway from this case is that essentially groundbreaking discoveries of naturally occurring relationships when using well-known techniques can fall short of statutory patentable subject matter eligibility. And, you know, at the end of the day, at first blush, a case like that may appear to be patentable subject matter just because it is a groundbreaking discovery, but as you can see here, that was not the case in that particular situation. So now turning to the claims in Thales Vision X versus United States, they were directed to a system for tracking the motion of an object relative to a moving platform using inertial sensors that directly measure the gravitational field or effect in the moving platform. And essentially conventional systems were flawed because they also used similar sensors, but they measured the motion relative to the Earth as opposed to the gravitational effect or field. And when relying on the motion relative to the Earth, they noticed that over extended periods of time, there were inconsistent position information whenever the platform accelerated or turned. And this obviously compounded over the course of time and numerous accelerations and turns. And so what the court did in this particular case is they relied on analogies to the unconventional use of thermal sensors in the well-known rubber curing case of Diamond v. Deere. And they ended up holding that the claims were not merely directed to the abstract idea of using mathematical equations for determining position, but the unique configuration of those, conventional inertial sensors in an improved system to alternatively measure gravitational field and effect as opposed to, motion relative to the Earth, which at the end of the day ended up resulting in more accurately calculated positions of the moving platform. So a key takeaway from this case is that in order to facilitate a favorable outcome during examination and litigation, it might behoove you to draft your claims in a manner to the extent possible that lend themselves to an examiner or a court being able to draw parallels or analogies to the claims of previously decided cases which did in fact hold the presence of patent eligible subject matter. So now turning to visual memory versus NVIDIA. The claims in this case were directed to a computer memory system configured to store a type of data in a particular cache memory based on the type of processor connected to the memory system. The court in this case held that the claims are directed to an improved computer memory system rather than the mere abstract idea of categorical data storage. In reaching its conclusion, the court focused heavily on the spec, which described a number of substantial benefits. And one benefit in particular that they appeared to be impressed with was the fact that there was an enhanced performance relative to conventional memory systems that had a much larger cache, as well as improved efficiency and reduced costs. So the key takeaway from this case is that, to the extent possible, draft your specification in a manner that clearly articulates the various advantages associated with your improved invention relative to conventional ones.
And going back to the first decision you talked about, it seems to me if you're going to be heavily reliant upon one of those, you better make sure to include it in the claims as well.
Yeah, most definitely, most definitely. So turning now to the claims in rapid litigation management versus cells direct, these claims were directed to a method of preserving hepatocytes or liver cells through multiple freeze-thaw cycles. And the court held that the claims are directed to a new and improved laboratory technique for preserving liver cells rather than the observance of a natural law that liver cells are capable of surviving multiple freeze-thaw cycles. And the court particularly noted that it was known in the art that freezing severely damaged hepatocytes, and that prevailing wisdom in the art actually taught away from freezing the liver cells more than once, and that if you were to freeze the liver cells after that thaw, you had to use the liver cells immediately or discard them. And what was interesting about this case is that obviously the prior art taught away from multiple freeze-thaw cycles, and the inventors found that repeating this well-known freezing-thaw cycle, actually prolonged the viability of the cells, enabled them to use more than just one freeze-thaw cycle to obtain viable cells in combination with a fractionation step. And the court found that this fractionation step in combination with the freeze-thaw cycles were essentially far from routine and conventional. And so a key takeaway from this case is that it would be beneficial to include within your specification any discussions of a prior art teaching away of a particular combination of well-known steps, because, essentially doing so may help transform the nature of your claim into patent-eligible subject matter. And one thing I really noticed when looking at this rapid litigation management versus cells direct versus in visual memory, the prior case versus NVIDIA, is that, at the end of the day, it appears to me that the courts are really focusing on what typically patent attorneys rely on with respect to secondary considerations.
For Graham decision.
With respect to Graham v. Deere. So, obviously, drawing these similarities between secondary considerations for overcoming a case of obviousness, if you have the ability to include some of those topics of discussion like, unexpected results or commercial success, long felt but unresolved needs, failure of others, in addition to like a prior art teaching away, that may go to great lengths to help the court rationalize or justify, an event of concept for transforming the nature of your claim into patent-eligible subject matter. So now we're going to switch gears over into claim construction with an emphasis on indefiniteness. So under AIA 112B or second paragraph pre-AIA, the specification shall particularly point out and distinctly claim the subject matter which the inventor regards as the invention. And so the United States Supreme Court has read this provision, in particular Nautilus, to require a patent's claims viewed in light of the specification as well as the prosecution history inform those skilled in the art about the scope of the invention with reasonable certainty. And this reasonable certainty standard is a higher threshold standard than what's typically applied by the USPTO with respect to broadest reasonable interpretation. So now shifting gears over into the first case, Sonics Technology versus Publications International. These claims were directed to a system and method for using visually negligible graphical indicator to encode information on the surface of an object. And this case is interesting because, at first blush, looking at visually negligible, obviously that appears to be subjective terminology that might render the claim indefinite. And the court noted that whether a claim is indefinite must be judged in light of the intrinsic record, which includes the re-examination history, in addition to the prosecution history pre-grant. And so the court held that the claim limitation was visually negligible was not indefinite in view of the intrinsic record. And they arrived at that because there were the presence of a number of specific examples within the spec, as well as a definition of particular requirements for arriving at a graphical indicator that was visually negligible to the human eye. And then they also noticed that, examiners during prosecution as well as the re-examination were actually readily able to differentiate between indicators that were and were not visually negligible. So a key takeaway from this case is, to the extent possible, provide specific examples as well as list particular requirements for claim terminology that may be construed as being subjective or vague and indefinite, during prosecution or litigation. So now turning to the GTAV case of ex parte MIC award, these particular claims were directed to a water detector configured to be reliably installed by an untrained installer or a homeowner to not require the services of a plumber or an electrician to perform the installation. And essentially, the appellants asserted that this configured to limitation would have been readily understood by a skilled artisan to mean capable of being installed without any special knowledge or tools. Essentially akin to a simple do-it-yourself device capable of being installed by an amateur. And the board noted that the specification failed on a number of grounds. First, to clearly define the structure encompassed by the configured to claim limitation, failed to clearly define the requisite skill level of an untrained installer or homeowner, and also failed to provide a description of the knowledge or tools required for the installation. And an interesting thing about this case is that instead of applying the reasonable certainty standard, which is the higher threshold standard as set forth by the Supreme Court in Alias, the board in this case held that the claim's configured to limitation was vague and unclear to a skilled artisan when given its broadest reasonable interpretation in light of the specification, which is obviously the lower threshold. So turning to the last case now is Alias versus Networks versus Apple. Obviously, we're all traversed in the doctrine of prosecution history estoppel, but for those that are not, what this means is that this doctrine is applied to ensure that claims are not construed in one way during prosecution to secure an allowance, as well as maintain their patentability, but then in a different way against an accused infringer during litigation. So essentially, you can't argue a narrow claim scope during prosecution to overcome a prior art rejection, but then in another breath argue a broader scope of protection to assert infringement. And this was an interesting case because this was a case of first impression for the CASC, and they held that prosecution history estoppel doctrine extends not only to prosecution, pre-issuance prosecution as well as post-issuance proceedings with respect to reissue and reexamination proceedings, but it also extends IPER, inter-parties review proceedings, both before and after an institution decision, as long as there's a clear, both a clear and unmistakable disavowing statement of claim scope. So they extended, the prosecution history estoppel doctrine to also include IPR, which is, like I said, a case of first impression. So with that being said, I'll turn it back over to Brian.
Okay, thanks, Dave. Interesting stuff, very interesting. I'm going to go ahead and touch on a topic that is, I found it fascinating sitting where I'm sitting because I work for a vendor that provides solutions and tools to patent attorneys, but I don't actually practice. And I have been able to chair different roundtables and discussions around preliminary searches of prior art in the past, and what I find is always interesting in that it seems like, and certainly this depends upon who's in attendance, but half of the folks who sit at the table vigorously research the prior art prior to filing, and the other half actively and completely avoid the prior art. So they practice a form of, I guess, active ignorance. I don't want to take a position on it, but talk to some of the things that drive considerations in both directions. The key thing, I think, to recognize is that we're a lot more exposed now to what we do through analytics, and that exposure is going to become more widespread with time. So just going to talk through some of the things to consider with preliminary searches of the prior art prior to filing. So the first is you can determine patentability, right? If you discover that an innovation isn't available, isn't something that you can pursue, not filing the application, not attempting to pursue it through prosecution, so it saves a lot of time and money, particularly if you have in-house counsel doing the work for you. I think that's an important consideration. The other thing, too, is you might miss the opportunity to preserve a prospective trade secret. If it's a process you can keep in-house, you're not sure you can gain patent protection, but it's something that you can guard carefully in-house. You don't want to lose the opportunity to do that. The second is you secure a more defensible patent. If it should be that there's significant prior art out there and the examiner fails to consider it and you get the patent, you know that your opponent will likely find that prior art. So better to have the examiner consider it and get the rebuttable presumption in your favor. The other thing is pinpointing the novelty of the invention. Quite often, it's hard to understand what's new. Where is the invention within the invention? What should you truly be pursuing here? You might miss the point entirely of what the inventor has come up with. And the other thing, I guess, coupled with that, another bullet, is you get an opportunity to enhance the design of the underlying invention. If you find that particular innovation you're dealing with or disclosure that you're reviewing shows a lot of promise in a given area, you may ask the inventor to expand upon that space and better understand their intent and their thoughts regarding that aspect of the invention. Identifying the potential risk of infringement. In a sense, when you do the preliminary search of the prior art, there are aspects of it that are much like freedom to operate search. Better to know that early as opposed to later. You don't want to file an application and discover one of your primary competitors has already secured the rights to the innovation you're hoping to cover. You can also, too, avoid early rejections. It puts you in a far better position to respond to rejections that come through the office. You can improve your language, the completeness, and the descriptive aspects of your filing. If you have a familiarity with the art, having explored the prior art, you may find better ways to verbalize some of the aspects of the invention, particularly if you're operating in a new area of art, either be new in that it's just emerging or new in that it's the first time you as a practitioner have ever dealt with it. We know it's required for pursuing accelerated examination. So the big opposing argument to the preliminary search are willfulness concerns, and that's understandable. The notion of treble damages, I think, makes all of us tremor. But at the same time, you have to believe that if there's significant art out there and you fail to discover it and the examiner finds it, all of that goes on record, you're going to have a problem anyway. So, you know, maybe better to deal with it early than to deal with it later, and particularly when there's the element of surprise associated with it when maybe you weren't expecting it. And the last thing is you want to avoid alerting competitors and other potential plaintiffs. When you file something that is subject to a 102 and you subsequently abandon, with analytics now, you have to believe that patent assertion entities, competitors are watching for that. And if they see that, they know that you may have in the marketplace an infringing product. One of the interesting characteristics about some industries is that the last thing they do in product development is file for the application prior to launch, which seems a little backwards, but we know that happens. So those are some thoughts on preliminary searches of the prior art. We're not trying to take a political position, but we think it prudent for you to at least consider both sides of the coin in your practice. So what are some tips for the practitioner? Kind of looking back now on some of the different things that we've talked about. We just mentioned the preliminary search of the prior art. Factor those pros and cons and figure out what makes most sense for what you're doing in the industry you're in and the players that's within that industry. I fully anticipate in the future analytics helping to drive a lot of decision making as to the level of engagement that you see in this space. Don't forget that opinion letters from counsel are extremely important. If you do uncover prior art that looks to be problematic, you don't want to not take some form of action. Use provisionals to secure priority. I think the mantra now has been file early, file often, brought on by the AIA. Probably won't change anytime in the near future. Ensure you have an enabling disclosure, particularly if you're filing a provisional. You don't want to make the mistake of not getting that right, particularly in this environment that we have now with first to file. Consider narrowing your claims. These big, very broad claims now can be problematic. I don't think Dave actually went into that, but we know that those create more problems now than they used to. Proof your applications and look for Section 112 issues and problems. There are a variety of tools now. We have one in-house patent optimizer that we've been selling now for over 12 years, and it identifies all the errors, anomalies, and issues as within your application. Do that prior to filing. Don't allow yourself to be subject to a 112 rejection. That's detectable in file history analytics. It presents delay in prosecution. It adds incremental costs, and it's something that can be easily avoided. You want to leverage file history analytics in prosecution. You see this emergence now of solutions in that space. We have one called Patent Advisor. And it's better for you to know where you're going to have great successes in the office and where you could have stunning failures, and not based upon any of your own actions, but based upon the circumstances you'll be dealing with given the behavioral characteristics of certain examiners. So look at file history analytics. They can help you determine a proper course of action given any situation as within the office, whether or not you should file an RC, whether or not you should appeal immediately, or maybe you should even consider abandonment or filing a continuation. So there are different things you consider with that. Anticipate analytics oversight. So know that I think some time ago, working with a patent attorney and filing a patent application was somewhat like taking your car into a mechanic. You knew they were doing the work, but you didn't understand what was happening. You didn't know where things were going and what the outcome would be. With analytics now, it'll be very easy for companies to understand how effective counsel has been for them, what has transpired within the office. They'll be able to benchmark that against the performance of other attorneys or law firms, et cetera. So it's going to, I think, become more important to establish a track record of success and of prudent decision-making. And then lastly, Dave pointed to some interesting cases, provided us with, I think, some rich information, some things to be apprised of. So try to abide by some of those key takeaways. As mentioned by Gail earlier, all of you will be receiving a copy of this PowerPoint, so definitely peruse through the PowerPoint, see what you think. So the last thing we're going to talk about are future trends. We've alluded to some of these, I think, already. We expect to see a wider adoption of efficiency tools and analytics, automated document analysis and error detection. That's actually been in the market for some time. We think it's going to continue to grow. Workflow automation, auto-generation of documents that are somewhat rote, IDS forms, that type thing. And then patent quality analytics as companies try to understand which components of their portfolio are generating value and which can be readily retired or removed or pruned out. We think patent quality analytics will emerge and become more widely adopted and accepted. Secondly, we're going to see predictive analytics in filing. We can use file history analytics to forecast examiner predispositions, predispositions of particular art units. We expect to see an ability actually to modify the language of your application drafts to better target those art units or areas of the office that'll produce more favorable metrics for you. We have a solution called Pathways that helps you to do some of that work. And what you're looking for are higher likelihoods of allowance, fewer changes to your claims being required, faster times to grant, and that'll make a real difference. So it's not just the substantive aspects of your application, but the procedural aspects that combine together to determine whether or not you're going to be successful. And then lastly, probably one of the most exciting things that I see coming are new technologies that are going to drive drafting of patent applications and responses. Now, when I say drafting, I don't mean the creation of an entire application or response, but there are aspects of applications and responses that are somewhat rote, somewhat redundant, predictable, and mechanical. And we think with the emergence of AI, deep learning / machine learning, that we'll see a lot of activity in that area. These new technologies are showing significant promise, but we'll always have human input and expertise sort of driving the key points in the application, the claims, the way in which the claims have been crafted, et cetera. So that's where we are. We've almost reached a full hour, trying to save a few minutes here for any questions that you might have. So Gail, I'll go ahead and pass things back over to you, and thank everyone for attending today. Hopefully you found some of this information useful and interesting, and we'll look forward to having a session with you sometime again in the near future.
Thank you.
Thanks so much, Brian. We do have one or two questions, if I can read them to you. The first being, any thoughts on automation of specification drafting with the input being a claim set?
Yeah, I think absolutely. We'll see a variety of types of input. It makes sense that it be a claim. It's interesting because you do have a bit of a mismatch in terms of scope. Claims are typically broader and the language is more generic, whereas specifications tend to be provide more detail, flesh out the claims, and also provide support to the claims. But I do believe wholeheartedly that we will see advancement in that space. A lot of the AI technology, machine translation technology will factor into that, and it would not surprise me at all to see that becoming very real. I can't give a specific time frame, but we know that we see advancements in that space. There's some smaller third parties who are playing with that today.
And that was actually a topic of discussion at the AIPLA this year. There were a number of seminars pertaining to that exact question. So definitely something to look for in the future.
Yeah. But nobody needs to think that they have to switch careers. Don't worry about blowing the dust off your resumes and exploring new opportunities and going back to school. Great. Thanks, Gail. You said there was a second
Sure
question?
thing. And also, can filing a continuation be a way to get a different examiner?
Sometimes. Yeah, you might want to comment on that.
It's possible, but quite honestly, when I was an examiner at the USPTO, typically, you know, continuations, divisional CIPs, they end up, they try to steer them towards the same examiner that handled the parent application. Now, with that being said, you know, there is, you know, a significant amount of turnover at the patent office. And in situations like that, you know, you might end up getting a different examiner within the same group art unit. So that's obviously a possibility as well. But like Brian said, you know, if you can leverage a solution like our Pathways, and we actually have a small slice of that in our Patent Optimizer solution, you can custom tailor your application to essentially try to arrive at the group art unit of choice, you know, prior to filing.
Yeah, trying to get the right examiner ahead of time rather than switch it later in the process. Yeah, exactly. You're better off. An ounce of prevention.
Exactly.
Yeah.
Well, thank you so much. I really enjoyed today's presentation, and I appreciate both of you being available for that, and look forward to sending out the slides and recording to those who requested it as soon as it's available. So everyone have a wonderful day, and thank you again to you, Brian, and to you, Dave.
Thank you, Gail.
Bye for now.
Thank you, everyone else.
Have a great day. Thanks for your time. Take care.
Bye-bye.